You know, earlier on, I was telling you about something very extraordinary. The AI, as in artificial intelligence-powered Galaxy S24 Ultra. Now, this is not just an ordinary phone. It is a revolution, a journey into the future of mobile technology. Now, with the new Galaxy S24 series, you can now circle to research for travel destinations or even search for products while shopping online. The Galaxy AI in the S24 series also has the live translate feature, meaning you have a personal translator in your pocket. And that's not all. The Galaxy S24 Ultra new camera comes with a slow-mo video recording feature. And you also get a powerful AI tool for adding or editing out content from images. You know what? Get yourself a Galaxy S24 Ultra today, available across the country, and join the artificial intelligence revolution. Still on the bench, two big brains on the bench. I feel so dumb today, but it's good. I'm getting a good lesson in jurisprudence. Gladys, the boss, is in the house. Dr. Otiende Amolo also in the house. I tell you, we're talking about the judiciary, the legislature, and the executive. And folks, I was asking before the break, boss, what went wrong? The president and the judiciary were like buddies. They were pals. They were mates when he was sworn in. 13 months later, it looks like loggerheads.
No, it's not loggerheads. We've just disagreed with it. He's disagreed with some of the decisions that they've made recently. It doesn't mean that he's an enemy of the judiciary now or that he has changed his mind. He has always supported the judiciary. The pledge even to make sure that they increase the budget of the judiciary, give them the opportunity to hire more judges and so on. So, yes, that even as much as we support the judiciary or he supports the judiciary, he can't criticize them when they don't do right. And I think this was a case where, because the housing project and the universal health care is actually an urgent need of millions of Kenyans. This is something that is so critical to the country that, yes, when the court makes that decision, and the court has made the decision in a vacuum, they should be able to look at world developments. Because even when we say about, like I told you at the beginning, that Kenya signed the UN Convention more than 20 years ago on social and economic rights. It has domesticated it. We have looked at what other countries have done, because you should ask yourself, if you look at the Scandinavian countries, the UK, the US, Malaysia, Singapore, they have undertaken the affordable housing projects using the same methodology that we're using. So yes, the question is, are the judges, are they reading world developments and seeing how other countries have done it? What formula then do they want us to use? Because they should give a proposal on what we should do to be able to provide affordable housing or universal health care to Kenyans.
I like it when you say we again. We as...
No, for me, the thing is, I campaigned on the Kenya Kwanza plan. And those are the same things that we told Kenyans. Even when I was elected, I told Kenyans, we're going to push to ensure that you get affordable housing. In Parliament, I was on the front line making sure that that law was in fact passed. Honorable Otiende Amolo here gave some, initially it was supposed to be a saving plan, which many people did not agree with, and then it was changed into a levy. So yes, all of us, so when I say we, it's myself and all those people who campaigned on that platform and on that promise to Kenyans. So there's nothing wrong. Yeah. I belong to a political party, and those are the things I promised Kenyans.
I respect Madam Shule. I've always respected her, but she's crossing a dangerous line of separation of powers. Because first, she is the deputy speaker, the second in command to the legislature, which under Article 94(4) must provide oversight to the executive. And so when the leadership of parliament says the language we in unity with the executive, then how will we as the legislature check the executive? Secondly, it is also wrong. It's also wrong on so many other scores. And Madam Shulei knows that if you were in parliament, her utterances here and some of her previous utterances I've seen too in recent times would have been out of order in 4 respects. First, under Standing Order 107, and she's always the first to call this, making unsubstantiated allegations. she has repeated those unsubstantiated allegations against the judiciary. In fact, she said that she promised the president that we will deal with them. You just wait. Secondly, she also breaches Standing Order 87, because Standing Order 87 prohibits us from discussing the conduct of any judge without a substantive motion.
I have not discussed the conduct of the judge.
She breaches Article...
I have discussed a judgment, not a conduct of the judge.
Standing Order 89, which is the rule against sub judice. This matter was in court. They have appealed. The appeal is pending. And then they go to funerals, and the deputy speaker herself speaks on this. Funerals, churches, speaking about the very same matter and attacking the judges for making that decision. And lastly, Madam Shulei also breaches Standing Order number 90 of conflict of interest. You know, Madam Shulei is conflicted to a certain extent. You know, historically, she's one of the founding registrars of the High Court. And as registrar, and it was within her discretion to make certain decisions. She made certain decisions, including about housing of the Court of Appeal, which all the judges rejected. And so it made her look very bad. And so, you know, there's also an element of conflict of interest. Now, I really would urge Madam Shulei, as our Deputy Speaker, to let other hawk-eyed people within the executive, those who are, you know, knee-deep, whether they are waziris or whether they are PSS or whoever they are, the Attorney General or the Deputy President, to make that case. Because when you make this case for the executive, you are not just diminishing your office, you are diminishing all of us. And that's why everyone says Parliament is dead. We don't want to be part of a dead house. Back to your question. What happened? William Ruto started very positively, and I agree and I commend him. By appointing those 6 judges, he did the right thing, something that should have been done earlier, and I agree. By promising and trying to increase the allocation to the judiciary, it was a good thing. Although the allocations that were promised has not been realized, but at least the idea is a very good thing. By supporting, and I'm in the Justice and Legal Affairs Committee, and we supported, and our colleagues from Kenya Kwanza also supported, the idea of increasing the number of judges, including the Court of Appeal, you know, which we have since increased. I think that's a very good thing. But it turns out, all these good things were aimed at one particular thing: control. They were all a bribe. Once he realized that this bribe has not worked, then he has now come out in his true colors. You know, because he was hoping that by being lovey-dovey with the judiciary, causing the CJ to sometimes handle him with kids' gloves, then he would have control of the judiciary the way he's had of Parliament. The difference is, in Parliament, if you have control of the leadership, it's easy to stifle Parliament because they control everything. But in the judiciary, the CJ cannot control the decision-making of individual judges and magistrates. And he quickly realized that he was backing the wrong horse. That's why he has totally transformed and is now attacking everyone. This backtracking of saying he's open to dialogue is hoping that by engaging the CJ can somehow impose some sort of directive on the judicial officers to tone down on making independent decisions that affect government. That cannot work.
No, first of all, I want to correct Omola here, because he's made some very serious accusations against me. First of all, when you say that I'm offending the sub judice rule, that is not correct at all. Sub judice doesn't mean that we don't talk about a case that is in court. It just prohibits us from talking about the merits and demerits of the case. But I can talk about the case. So I have not offended the sub judice rule at all. You have also accused me of making unsubstantiated allegations. What allegation have I made? I have simply critiqued a judgment. That is not an unsubstantiated allegation. Number 2, when you say that we are prohibited as Parliament from discussing the conduct of a judge, I have not discussed the conduct of any judge in this particular show. Yeah. I have simply said I do not agree with the decision. And that is why the matter has gone to appeal.
Well, I will leave it at that. You will, the viewers and yourself can look at what my Honorable Shulei has said before. You will see that she did not critique a judgment as well as the president. They've been critiquing the judges the individual judges to the extent that the deputy president has even named one. I think Honorable Shelley named another, you know. That is not criticizing a judgment. That's criticizing the judge. That's different. Secondly, the sub judice law is very clear, and Madam Shelley has made this clear in Parliament all the time. When you are discussing an active matter that is pending in court, and you are saying, as they are saying, that the judges are actually frustrating the program, you are discussing the merit of it. But I will just leave that there.
All right, I think it's
those are accusations against other people, not myself.
There's been a lot of feedback on this topic.
Yes.
So let's get to the magic wall, see what the folks have to say. Tweets coming in thick and fast. Frank Orinde says, let me get my glasses there. There's nothing like calling the judges out. The president is clear that there are judges who are corrupt. The question is, why can't he follow the laid down procedures through the JSC? Initiate a petition for removal from office. We asked that earlier on, boss. Why can't he do that? Go through the legal process.
There's still time to do that.
Okay. Cornelius Limo says, justice can never be served in an environment where intimidation and threats are used as weapons. Kenya Kwanza government is taking us back to the dark days. Senior counsel, you alluded to that, didn't you?
Absolutely. Absolutely.
And boss, do you disagree? We're going back to the dark days?
No, we're not going back to the dark days.
Engineer Lazaro says, Honorable Boss, you served in the judiciary for quite a number of years. You know the constitutional ways of dealing with the said errant judges, not mob lynching as per what KK leaders have been championing. Do they need to be called to order, boss, just to tone down their rhetoric?
Yes. The judges? Who do you mean about?
No, the KK legislators who are calling out the judges.
You know, the thing is, what makes Kenya a good a democratic country is that people can be able to speak openly about these issues. Nobody should be covered from not being criticized. We do it to cabinet secretaries. We've called out certain members of the executive who work in various commissions, and you can call them out.
Okay. Brio Okoth says, the impunity displayed in Kenya by openly defying court orders shall come to haunt the perpetrators, wapende wasipende. Lucky Boy Maingi says, let's respect the independence of the judiciary. Respecting the judiciary ensures the preservation of the rule of law, upholding the principles of justice and fairness, and maintaining a crucial system of checks and balances in a democratic society.
And you know, Jeff, personally, I've been very supportive of the judiciary. I have, in fact, I'm seen as the ambassador even in Bunge when I've sometimes lobbied for them because I understand the challenges the judiciary go through. I have worked there, yes, but that doesn't mean that if we don't agree with them, we can't say it.
You can agree to disagree.
Yeah.
Senior counsel.
And it's a good thing for the judiciary. If you look at the history of the judiciary, the way it has improved over time is because of criticism against the judiciary. From the time of President Kibaki, when there was the what was it called, the radical surgery, and then thereafter, the Chief Justice after Chief Justice has raised the issue. So it's not the first time we are raising the issue relating corruption. It was said during the Kibaki regime, it was raised. Even Justice Maraga, if you looked at his first speeches, he also alluded to that. So did Justice William Mutunga at that time, Chief Justice William Mutunga. So it's not the first time that conversation is being had. But it should just, if we use it as a chance to reflection and to continuously try and improve the judiciary. Because it's a continuous process. And I believe if you look at the judiciary now and the judiciary that we had many years ago, when the president used to appoint the judges by himself with no Judicial Service Commission, we have come a long way. And there's been great improvement at the judiciary. But there's still room for improvement.
Sure, lots of room. Joel Mbithimwala says, Cholet should define affordable. 4.3 million is affordable? Boss?
You know what makes it affordable is that if you look at the cost now that people use for buying houses is much higher. But also this one, it allows somebody to make as little payments as 4,000 shillings. There are in 3 categories, those housing. There's social housing, and then there was affordable, and then there is the market rates. So you'll find that someone who has been paying for a shack room in Kibera will be able to pay the same amount that they are paying in rent now, but in a proper place which has good sanitation, proper facilities, a school nearby, a hospital nearby. So it is affordable in that the amount is quite low. And they are paying it over a very long period of time.
Senior counsel.
First of all, the rendition of history. The rendition of history that Honorable Shole has rendered is not entirely accurate. It's not, we have not come this far out of criticizing the judiciary. We have come this far out of building institutions and creating institutions through which, if you have any legitimate complaint against any judicial officer, you can go and there's a clear process. Up to the year 2002, there was no such clear process because the entire JSC was controlled by the president. And that's why you'll remember in 2002, I was the chair of ICJ, and we brought in the whole team of Commonwealth experts who were to probe the judiciary because there was no basis, chaired by Justice Kanyaihamba. Shortly thereafter, we then had what President Kibaki called the radical surgery. It turned out to be a surgery by radicals because it did not have a proper foundation, and it ended up being a targeted tool. It was just targeting individual judges. And Justice Ringera was the first to admit recently when he was being interviewed that with now what he knows, he would have handled it differently. The first proper process we had was the post-election process, one of the Agenda 4 institutions, which I think was chaired by, I think Roslyn Odede was the vice chair, and I think
Justice Albi Sachs.
Albi Sachs was that was the other one.
Board.
The vetting board. It was a proper one where you could bring any complaint, it would be handled properly, giving you due process, and they managed to remove so many judges. Now we don't need that because we have revamped the JSC, which has representatives of virtually everyone, including the public, including the president, including the judiciary and the advocates, and it's a proper body. If you think that JSC cannot handle it, then what you should do is suggest we disband JSC, and there's a process for that. But you can't sidestep it. But secondly, is this question of what's the affordable housing. On this topic, we are limited to the judiciary. And so far, the judiciary only pronounced itself on the constitutionality of the process. The judiciary does not go to the reasonableness. Now, that was for us to examine in Parliament. We didn't. We were not given space to. But one of the things I raised in Parliament, for example, this whole affordable housing scheme, is the question of who pays. And should it be mandatory? A teacher who's teaching in my local village in Chianda, and he comes from his own house and goes to teach, and goes back to his own house. Why should he make him pay for affordable housing and he does not need it? Why should it be mandatory? The second question is who benefits? Let me tell you, up to now, and if you ask Honorable Shole right now, what is the scheme of making sure that people who are deserving benefit from this, there's none? So in terms of reasonableness, there's so much to say, but we've only limited this debate for now to the constitutionality of taxation without legislation.
Absolutely.
No, there is actually a formula of how people can apply for those houses. Obviously, you haven't logged...
Not applying, benefit. Yes, ultimately, yes. Anyone can apply. Yes. But who benefits? They started saying it will be hustlers. They said now it will be Mama Mboga. Then now they put a threshold where anybody can apply. So ultimately, the people who will benefit are actually people who already have houses.
Okay. More tweets, thick and fast. Mac Botongore, hey Mac, here's what he says. In 2010, there was a general consensus that there was 20% of the COK that wasn't acceptable. And so it was, quote, we pass it and review it later, or we review and then pass it. Yes, carried the referendum then. When shall we address this 20% that was unacceptable? Interesting. Interesting.
Yes.
Folks.
Yes, so I think you need to go and look at how the regulations have been put, because there is what they are calling social housing. This is the lowest interest rate, and it is for the people who are at the bottom of the economic ladder. And then you have affordable, and then you have another at market rates. So it's very clear who benefits. Like, for example, you don't qualify.
But nothing would stop me from applying. That's the point. And in any event, what you are talking about is actually contained in the bill. You see? The fact that it's contained in the bill is an admission that it should not have been passed in the first place without this foundation. Because the foundation should be a bill that proposes some money to be paid for affordable houses. Then Kenyans can debate. Should it be mandatory or not? How much should it be? Who should benefit? But they put the cart before the horse. They imposed the amount to be deducted. Then now they are coming with the basis of deduction and who to benefit. It's an admission that the court was right in the first place.
No, but this was clearly debated in Parliament. Many people appeared before the Housing and Finance Committee.
It was not in the finance bill. It could not be in the finance bill. That's why now it's in the draft bill, which they're purporting to do public participation on.
Right.
This is what should have been done first. Before you introduce it in the finance bill for taxation, you introduce the basis. And Kenyans then would have the opportunity to say, we actually don't need houses. We just need food. We just need other things. Don't tax us further. And it is, you work for Kenyans. You don't just impose policies because you dream of them. Even you, let me tell you, if I think you need a bicycle, and you come and tell me I don't need a bicycle, me I just need a sufuria to cook ugali, who am I to impose the bicycle on you? So those are discussions that should have been had. Nope. If we agree we need it, then we come to the how. If we agree on how, we come to the who. Once we've agreed on that, then you can tax.
No, you know, he's making it look like this particular program just started from nowhere. This program has a genesis. It is even in the Constitution. It says the state shall provide.
The Article 43...
So it's already in the Constitution.
Article 43.
So you cannot now say that you're imposing something in Kenya that you don't want. They
that's
passed
misleading.
The Constitution.
That's misleading. Article 43 is clear. Yeah? Those, rights in terms of the right to food, the right to health, the right to housing, they're all there. Does it mean the government is entitled to give you free food today? No. And it is there. Does it mean the government is entitled to give you free water and free health? No, and it is there. So the fact that it's mentioned, this is one of the progressive rights where you must discuss how to achieve. You can't just come and impose because it's mentioned. That's not how Article 43 works.
In fact, we are 10 years late,
yes.
Because when it says that we should have been progressively trying to achieve those rights, we should have started 10 years ago when the Constitution was passed. It's just that we are 10 years late and we are doing it now. And the government must put in those measures. They can't just say, and we can give it to you at a later date. It is something that we all pledged and agreed. And we are not the first country to do it. Other countries have done it.
I'm getting worried. The senior counsel is referring to his constitution.
I wanted to
read Article 43.
I wanted to remind Honorable Shule of the exact text of Article 43. Because it can be misleading for somebody listening to think, oh, the Constitution requires housing for Kenyans, therefore they're imposing. That's not how it's phrased. Article 43 talks about, the social and economic rights, yes? And the highest attainable standard of health, which includes the right to health, service including reproductive health care, accessible and adequate housing, and to reasonable standards of sanitation, to be free from hunger and to have adequate food or acceptable quality, to clean and safe water, to social security, to education. Are they giving all these things for free because they're mentioned in Article 43? No. Article 43 is progressive. It's progressive, and it tells you that the state should work towards achieving that.
And that is
the idea, let me explain. The idea of having affordable houses for citizens is not a bad thing. The idea. That's why I was saying it's the execution that is a problem. First, you cannot impose an obligation on everyone to pay for affordable housing, including those who don't need. You know? You can't. Why? And secondly, you're imposing it at a time that Kenyans are so heavily taxed on virtually everything, they have no food to eat. But you're imposing on somebody who already has a house and just wants food to eat, to pay for somebody else to get a house so that you can die in your own house. You know, what's that? And you must then agree on the idea, whether it is good. You must agree on how to execute it. This same article talks of the right to food. Will you then pass a policy saying every citizen will be fed breakfast, lunch, and dinner by the state? Of course you won't.
No, but it's...
For that same reason, you know, when in the hierarchy of needs, food comes even before housing. So you should start with food. Right now, most people cannot afford food, but you want them to pay for houses they don't need. It's unreasonable.
Like you rightly say, these are rights that will be achieved progressively, and the country must start from somewhere. Even the issue of food, that has already begun by making sure that you give subsidized fertilizer so that you can promote more food production so that there can be sufficient food in the country, so that we don't become a food deficient country. So all that, there are steps that have begun. And so for you to say that we should do nothing and not provide it, that is wrong. It must start from somewhere. And furthermore, you must realize that people are taxed to be able to provide services. For us to have schools at the moment, people have to be taxed. For counties to have money to provide healthcare and promote agriculture, it's from our taxes. So taxes must be collected for the country to be able to do their programs. So I don't know what other methodology you have that funds can be collected to undertake government programs.
But no country ever developed by overtaxing its people.
Absolutely.
You have to agree on that.
And right now, they're being taxed to death. You are talking of some imaginary houses to be built for people, and you're doing a number of things. First, you are imposing taxes on people who don't have food to eat. That is the most basic. In the hierarchy of needs, it is food, it is water, before you even come to housing. These are people who have no food. They have no water, but you are jumping the hierarchy to housing. And in the course of it, and this is the irony, you are even bombarding houses of people, like happened here in Ruiru. Yeah? People who have their modest dwellings. You are rendering them homeless in the distant promise that they will get some home, buying at 4.3 million, and these are people who cannot afford 100,000 or even 500 for food. How can that be providing? The Constitution itself, you know, Article 40, requires that you should not displace people, even if they're not entitled, but that accommodation and where they are, you should not displace them. But now you start by displacing, because you want this grandiose project of saying that at the end of 5 years, we constructed 5,000 houses. You know, that an idea of affordable housing that is not well put leads to this. You see what has happened in Kibra over the years. Every time they remove those slum dwellers and then they construct some houses for them, what happens? It is the people, the middle class, who come to buy those houses, even when you allocate it to them, because their need is more basic than that 2-bedroom house. Their need is food. So then, even if you give them, they'd rather sell it and they go back to some slum and get some food.
No, I think Honorable Omol, this one you're really misleading Kenyans, because what you're really propagating is that we should do nothing and that there should be no development and that we should just give up and say let people live in slums. This is a journey of 1,000 miles starts with the first step. We must start a step. There must be a deliberate decision. Because I know you're criticizing that because you know it's a good program. And because you're in the opposition, you don't want even to see anything that is positive that is being done. Believe me, those people in Kibra don't like living there. Today, when you say people don't have money, and I think if you saw what was the time when it was being presented before Parliament, they were giving us the example of Mukuru Kwanjenga, where people pay 3,000 shillings for a room that doesn't have sanitation, doesn't have any bathroom facility, doesn't have water, doesn't have electricity. We are saying those people will now be able to pay the same amount that they would pay for that one room, but a decent housing. And we must start there. I don't think you're a patriotic Kenyan if you think that you are happy seeing people living in shacks as they live in Kibra and Mukuru Kwanjenga.
All right, folks,
That's
I think...
absolutely not what I said.
Okay. You know, but, we can discuss this, debate this forever and ever, and we can go on, but it's a great topic of discussion. And at the end of the day... And
all that was discussed in Parliament at the time when the law was being passed, and it was part of it. It's just that they decided...
Can I tell you, and I make a full disclosure, Parliament, especially the National Assembly, under our current leadership, is not Parliament. It is not a house of debate. Traditionally, you say that in Parliament, the minority will have their say and the majority their way. Granted, the regime has the majority and they have killed the constitutional idea of separation of powers. But they've gone further. And I dare you to watch the proceedings of Parliament any day. They will bring issues as serious as sending policemen to Haiti. And they will not allow debate at all. They allow two people, the majority leader, to speak endlessly. After he has spoken, maybe one person, then they say, could as many as of that opinion say aye, and it's aye. We are robots. There's no debate. You cannot benefit from any debate in Parliament. The things we say here, we will never be given the opportunity to say them in Parliament, even when Madame Chouley is sitting in that seat. My last comment on this. Do you know what William Samoei Ruto is doing? He is so dangerous, not just to the country, but even to himself. So much so that those who like William Samoei Ruto, like Honorable Chouley, should advise him to desist from that trajectory and respect the courts. When he says that the courts are corrupt, he will not respect decisions of the court that he does not agree with, then those of us who disagree with him could choose to agree with him. And then we go back to the first decision was made that made him president. And we all say, you are not president. You have no cabinet. You have no, deputy president. So let us each decide who our president is. If Kenyans were to do that in agreement with William Ruto, where will we be?
Anarchy.
So in fact, those who like him should advise him that for his own benefit, he should desist.
Okay, boss, you get the last one.
Yes, but I think he's making it sound like the government has disobeyed any court orders. We have not. Even as Parliament, we have not disobeyed any court orders. They have promised. That's why we have proceeded to appeal, and we have honored all conservatory orders. So we are not in anarchy, as you try and put it. I think that's a narrative that you have developed, and you want to prosecute it and make Kenyans believe that that is the case. So far, there is no order that has been disobeyed at all, both by the National Assembly and the executive.
Jeff, is Honorable Chouley contradicting the president when he said that he will not obey court orders that he does not agree with? Is she saying that the president did not mean that he meant he will obey court orders?
No. He said he will not obey court orders that are not correct. Yes, but so far, he has not disobeyed any court order.
I'm glad
and that is why we are still in court.
I'm glad we have agreed to disagree on the bench. By the way, Senior Counsel, if you ever want to come and debate, since you can't do it in that rubber stamp of yours over there, the bench is always open.
And again, it's very sad that a senior member of Parliament can say that about Parliament.
Can admit, and I'm admitting.
No.
That is the reality. Ask any member of Parliament.
In fact, actually, but those are things that can be checked.
In fact, that's why we no longer have quorum.
He speaks a lot in Parliament, actually.
Yes. That's why we don't have quorum in Parliament. People have given up.
But you've participated in various bills. Yes. The people who have given up, there are people who, of course, they just don't want to participate in Parliament. But you, on many occasions, have spoken.
I try my level best, and I succeed one out of 10.
Well, you succeeded here tonight, folks. Thanks so much. Senior Counsel Dr. Otiende Amolo, MP for Arieda, and Gladys the Boss, Deputy Speaker, National Assembly. What a great debate, folks, going forward. I hope you've learned as much as I have on this day. But when you have big brains on the bench, you know this show is all about you and us and the country. Remember, every Wednesday, it's all about those three letters on the keyboard that follow each other. JKL. Thanks so much for being a part of the show. Good night. Good luck. God bless Kenya. Well done, boss.